239-479-5592. There is the phone number and the text line, the Tri-Town Construction Talk and text line. Usually we do the top 5 audio clips of the day, the 5 at 8:35 right now. But anytime that we can speak with Jenna Ellis, constitutional law attorney, of course, attorney to President Trump, senior legal advisor, anytime that Jenna Ellis can be on this program, I'm preempting for her. That's right. So usually we do the 5 at 8:35, but no, because I need Jenna's time today because I got a lot of questions. I'm so happy you are here, Jenna. Good morning. How are you?
I'm great. Thank you so much for having me. And, 8:35 is a great time.
It's a perfect time. It is a fantastic time, except I would like to have you here and talk about things during happier times, but I'm confused. I'm worried. I got lots of questions because I came into this morning thinking, all right, I really want to know more about the tax records case in front of the Supreme Court. There were some other issues that I wanted to bring up, but Jenna, you have to help me out here. Why is it that we're not this morning talking about the already dismissal of the Flynn case by the judge in the Flynn case? Why hasn't this happened yet, Jenna? What's going on?
It should have. And this is just from start to finish has been a complete miscarriage of justice for Michael Flynn. And we have now seen and have proof of what Flynn and his better attorney, Sidney Powell, have said all along, that, he was set up. It was a targeted prosecution, a malicious prosecution, and then a coerced guilty plea. He had incompetent counsel initially for that plea. And, there's just so many things wrong with this case. And once Attorney General Bill Barr had the United States Attorney's Office conduct an independent investigation into this case, then their investigation yielded all of this exculpatory evidence, which falls under what's called the Brady Rule, which basically means that as a prosecutor, if you are a government attorney with a criminal case, you cannot withhold any exculpatory evidence or anything that would prove or even help prove that the defendant is not guilty of the charges that the government is bringing. But that's what happened in this case, is that the prosecutors withheld all of this evidence that we're now seeing about how Flynn was maliciously targeted. And so it's just, for that reason alone, the law requires that this case is dismissed. And so, again, there's a motion to dismiss, but it's not even from the defense this time, talking about all of the problems and the coerced plea and all of the other legal reasons. This time it's coming from the government. The government is saying, yes, we screwed up, and there is the Brady Rule that was absolutely wrong of the prosecutors. And now, that should just be a complete no-brainer for Judge Sullivan. This is routine in any other case. And so the fact that it hasn't been done yet is absolutely ridiculous. And so I just wanted to go through that because the pushback, of course, from so many people on Twitter is, well, he pled guilty.
Right.
Well, you have to understand that a guilty plea is just a contract to resolve the case between the defendant and the state. There are often times that guilty pleas are either coerced or manipulated, or the defendant just thinks they have no other option. They don't want to risk going to trial. And in this case, Flynn was threatened and he was coerced. And absolutely, this guilty plea needs to be withdrawn. That doesn't mean that he is actually factually guilty.
Yeah. I noticed on your Twitter page that John Cusack, actor du jour of one individual in Hollywood who seems to know more about the law than you or anybody else, wanted to bring this up as well. When you made that comment, he's saying, we're constitutional law experts. Come on, camera, explain why Flynn pleaded guilty. You do it all the time, Jenna. How many more times do people have to do it? You and others. They not have TVs in Hollywood where John Cusack is up on his giant Grand Mountains, where he's closer to the stars than the rest of us. It's hysterical, but that part of it's hysterical. What is happening is not. Who's putting forward? Who is it that is doing this right now? I guess people are kind of confused. the reason why the judge has yet to dismiss the case is because it has been presented that a third party has now presented to the judge and said that they want to try to find more evidence that what was claimed. That's what people are confused. Like, so
right,
and
right.
who's presenting this?
It's a completely stupid pretext and a stupid reason for the judge to just delay. So what happened is that a group of third-party leftist attorneys who are former prosecutors from the Watergate scandal, have now said that for some reason they want to comment on the case. They have no standing. They have no evidence. They're not trying to do anything except intervene in a way that's not actually allowed by law in this case. All they want to do is present what's called an amicus brief or a friend of the court brief. Now, those happen routinely. We're familiar with those in Supreme Court cases where, so for example, you could understand how a lot of groups and other interested parties who may be affected by the outcome of a Supreme Court case would have a reason to say, justices, we want to be heard on a specific legal argument related to this case. Well, those are always proper generally in front of the Supreme Court, other appellate cases. But this is a trial court, and they're not presenting, this group of attorneys isn't presenting anything new factually. They're not presenting evidence. They're not even being witnesses.
Right.
All they're saying is, hey, we want to comment. I mean, why isn't Judge Sullivan listening to this program? And frankly, he should. I have better commentary than the Watergate prosecutors because I'm actually talking about the law, whereas they're not. They have no standing, no reason. And the thing that is crazy about this, Drew, is that in Flynn's own case, other people who were wanting to present other amicus briefs and other types of intervention and statements on behalf of Flynn, 24 previous times in Flynn's own case, the same judge, Judge Sullivan, rejected those interventions and said, no, your remedy here is not on the court's docket. And he cited the rules and said that, this is improper under the federal rules of criminal procedure. So what's the difference? Oh, sure. Just because this goes against Flynn. Yeah.
Right.
So he's reversing himself in his own case. That's how tragically biased he is.
Jenna Ellis joining us on Daybreak 92.5 Fox News, constitutional law attorney, senior legal advisor to the president. We're talking, well, among other things, right now, the fact that the judge in the Flynn case has not dismissed it yet. I guess maybe, Jenna, this question before we move on. What's the benefit? What would, besides stalling or like what could that side see happening that could change anything about this case besides just prolonging the inevitable? What could possibly happen? Why would somebody do this? What result would they want to see to benefit that side?
Well, just like everything else that the left will do anything to frustrate justice and the rule of law, and they absolutely hate President Trump and anyone associated with him.
Right.
So even if it's to just continue to harass Michael Flynn, who has gone bankrupt in this case, he's lost everything. I mean, thankfully his family is still supportive of him, but that may be a reason. And also, look, I mean, this is now for political purposes being used to the left's advantage, because now a lot of people are citing citing these prosecutors who they claim are so independent, and now just claiming that this is such a purely political reason, and because AG Barr wanted this new investigation, they're now again calling for his resignation. Yeah. I mean, nothing of this is based in fact or law. It's purely political, and they will do anything and manipulate any rule just to their political advantage. So to me, it appears that it's completely politically motivated.
All right, yeah.
Just like his original prosecution was.
Right, exactly. Why not? Why not do this? Look at everything you've done previously. It just makes sense that you would do something like this and give some, possibly the media, the opportunity to spin out of this to make it sound more like it was politically motivated, that the attorney general would do this. The judge might consider to dismiss that it was all something that was pre-planned, and it was the president and the attorney general in league with each other to do something that should not have been done to begin with. It just makes sense that they would put this out there. The other case, Jenna, that I wanted to mention, because to me, this is a pretty big deal. The one dealing with the president and the subpoenas for his tax records. I might suggest that the stakes here are, may I say, huge. Are they not? I mean, this is kind of a big deal how they're going to decide, or am I wrong?
No, absolutely. And, it's also interesting how much the focus of the mainstream media, even including Fox News and, the regular channels that a lot of conservatives watch, are so focused just on the coronavirus. There's so much else going on that typically, we'd cover in the news. And these cases that were argued in the Supreme Court yesterday absolutely are crucial, not just for their own sake, but also for precedent.
Right.
Because what happened here in the issue is the extent that a sitting president can be subject to congressional oversight under the pretext or the auspices of valid legislative purposes within his private dealings before he took office. And so Congress, it's a separation of powers issue, because what could Congress possibly legislate that they would need, or it would even be helpful for them to get the president's personal tax records before he took office? Because the presidency and the office of the president is constitutionally created. So it's not like, for example, the Judiciary Act or, where the Constitution in Article 3 says that besides the Supreme Court, any other courts that Congress may establish. And so, what if this were, and this is an interesting question that my friend Alan Dershowitz then tweeted after the arguments, where he said the one question that wasn't asked by the justices would be, so what if Congress was trying to subpoena their personal tax?
Right. I remember that, yeah.
Would there be something different, right?
Right.
And so Congress hasn't demonstrated any purpose or what statute would possibly be valid. This is clearly just to try to harass the president. I mean, again, this is political from the left, but the precedent here is shocking because they're trying to add criteria to the U.S. Constitution for fitness of office of the presidency that they are not constitutionally able to do. So this does have a wide-reaching precedent value here, and I'm hopeful that at least a majority of justices will choose the Constitution over activism.
Yeah, so I wonder then, Jenna, at the end of the day, listening to the arguments and what has been said up to this point, you getting any feeling as to how this is leaning? What it sounds like, what we may get at the end of the day?
Well, I listened to to most of the oral argument in the cases yesterday, which now, by the way, we can live stream for the first time, and I think that's a great idea. Even though the arguments are now being held, remotely, which I feel bad for the advocates. It's probably really hard to do that by phone instead of having those other nonverbal cues that you have when you're actually in front of the bench. And I tend to not speculate or read a lot into the questions that the judges ask from the bench, because the reality is, they're looking for responses and, maybe other finer points to convince their colleagues of things. And, there's a lot of speculation about how much impact oral argument actually has on the outcome of the case. But I think that overall, just understanding the composition of the bench, that we will get a favorable outcome here just because the Constitution requires it. And I think that we can say safely that we do have an originalist bench, even though Justice Roberts, of course, is the one that's always teetering on that. But I think that he'll be solid on this case.
Right. And there's no precedent, right? And there's no legal precedent for all of this to begin with. Right. So that helps. And that's the point, right? You don't want to set that. You don't want this case to be the case to set that precedent in the future. All right, Jenna Ellis.
Right, because this is more about every other president.
Right.
After President Trump's 5 years, and we're certain about that. He's going to have another 5 years. I mean, there will be presidents after him, and so, but the left is so short-sighted, and they hate him so much they're willing to attack him and set terrible precedent for future president. I mean, look at what happened with impeachment.
Right. And give the president credit, because that's something that he talks about time and time again, that he doesn't want to see any of the things that have happened to him happen to any other president. He doesn't say to any other Republican president. He says any president. He doesn't want this to happen ever again. So give him credit for that. And I know our audience does. But for those that do listen and watch on YouTube at Drew Steele Radio that are watching right now, I know I see your emails and I know who you are, and I know that you probably disagree. But if you listen to Jenna Ellis more, she'll change your mind on all of this. So that's what you need to do. All right, Jenna.
That's why I come on anytime. Thanks so much, Drew.
All right, we'll see you soon. I appreciate you. All the best.